For now, though, let me bring in my guest here in studio. Let's have a conversation. Joining me from my extreme right, Steve Ogola. He is a lawyer. Thank you very much, Steve, for your time.
Thank you.
We also have James Mamboleo. Thank you for your time, James. He's also a lawyer. All right, gentlemen, I'd like to start with a very maybe simple but complicated question. Just a day, actually hours to October 26th. Do you think that this election will actually happen?
Thanks, Betty. The question of election happening is not open to debate. Because even the election will happen, but even before we go to the details of the election, it's very important to disclose and declare your legal philosophy, because it then helps to frame issues, how you process them.
Right.
You know, do you believe in the rule of law, fidelity to the rule of law? And therefore, if you're looking for questions, for solutions, you are looking for solutions from the foundation that the law is the point of departure, or you are looking for solutions from wherever they may be found. So I think my view as a person, as a lawyer, is that is the one that appreciates strict fidelity to the Constitution. And if the law has gaps or maybe requires development, the development of the law must be such that allows for harmonization, what lawyers usually call a purposive and beneficial approach.
Wow.
So that you don't innovate within the challenges, but use the law from the point of departure. If you have that kind of view, then it's very easy to locate some of these political challenges, and some of them actually will be solved. So the question, like whether we'll have election or not, is a moot question for all practical purposes, because the Constitution says so, number one. The Supreme Court said so. The High Court in Ekuru judgment said so.
Right.
Insofar as those judgments have not been vacated, elections on 26th of October are very much well placed in the law, the foundation law.
Will happen, but you're saying that, so are you saying that, you know, it will happen, but whether there is fidelity to the law, that's the question?
No. The question, there are three issues around this election.
Yeah.
One is the question of legality of this election. I'm saying the legality of this election is not in doubt, Betty.
Yes.
Because the election is founded in the law, and if we are to express fidelity to the law, that which the law has ordained must be respected. Remember, the Constitution is our article of faith. It provides the pathway upon which you're supposed to organize our affairs.
Right.
If the Constitution says, Article 140 sub Article 3, that if the election of the president should be invalidated and a fresh election be held in 60 days, it is not open to us to debate it unless there is a further judicial interpretation that vacates that date. So that's the first issue. The second issue around this election, and then it's possible to put each issue in whatever basket that is required. The second is the issue of legitimacy. Now, legitimacy is a political question, and that is what is the ongoing debate around this election.
Yes.
They are legal, but are they legitimate insofar as half of the country are not participating? Now, the question with legitimacy, it could be discussed before the election or even after the election. Then, of course, there's the third issue about the legacy of this election, because Uhuru Kenyatta, if he's going to succeed himself at the ballot, he also cares to succeed himself in an election that everybody participated in, and then his last term should be served in a manner that is not disruptive. So I think there are those three issues. The first one which I've answered, the election will go on by law as established and required.
All right. Mamboleo, your take on this?
I want to speak to Kenyans today and tell them that it's extremely important as a nation that is founded on a constitution. A constitution, Betty, is the social contract that Kenyans have written and given unto themselves, and by which they will be governed. So this same constitution gives certain rights and freedoms, and one of them is the right to participate in elections, either as a candidate or as a voter. And the election that we held on 8th of August was an election that was held pursuant to that constitution. Well, under Article 140 of the Constitution provides a dispute resolution mechanism in the event that any player within the presidential election is dissatisfied with the result. And it tells you, go to court, to the Supreme Court for this matter. The Supreme Court has original jurisdiction and final jurisdiction to hear and determine that petition. And Raila Odinga, after some thinking, actually proceeded to the Supreme Court and obtained a judgment which annulled that presidential election. So that same Supreme Court, under Article 140, sub-Article 3, stated in categorical terms that, hey, Kenyans, you didn't do it very well this time. Go back within 60 days, as stipulated in the Constitution, and do this election again. So this is what I want to tell Kenyans today, that it's extremely important that we abide by the social contract that we have written ourselves by which we are governed. Because if we fail to do so, and we escape out of this 60-day window that we have given in the Constitution for the repeat presidential election, then we move into a realm in which the Constitution no longer tells us how, when, and through what process that particular election should be done. There's this line of thinking by some commentators, for instance, who think that we could go to the Supreme Court and ask them to extend time. That is not guaranteed. The basis on which to extend that time should also be founded on the Constitution. And we are not in any particular unique situation in which, legally speaking, we should extend the election. You don't just walk into the Supreme Court and get an extension. You have to lay very good ground for that extension. But then why the extension in the first place when we should conduct that election the way we should in accordance with the Constitution? And if there are issues around that election, then you can deal with it later. Now, maybe to finish, I think what I need to say is it's extremely important to recognize two things. When some section of the country says there will not be an election, and then probably they need to clarify a little bit what they mean, because there's a difference between there not being an election in the sense that IEBC has not organized and staged an election, as opposed to a section of the country boycotting an election, and they are very well within their rights to do so. All they need to do is to stay at home so that to respect the rights of those who may choose to participate in that election. We understand that there are many issues in this country. They will not be solved between today and 26th. A general conversation needs to be held probably in the future to try and solve some of these issues.
And even as it's just one question, and even as we look at, if this election will happen, if, it will happen, as you're saying, it's by law that it should actually happen. Does the political environment in the country matter?
It does matter, Betty, and we can't, it's not open to us to ignore things that are obvious to the country. What is settled is this. Until there's a court order vacating this election, it's not open to us again to debate whether the election should go on or not. Election will go on if the court, if no court has vacated the election date. Now, that does not take away the legitimacy issues around this election. And I was saying that one of those pending cases, the Harun Mwau case, which is pending before the High Court, and any other person who may move to the court today, if somebody presents an argument for deferral of the election, it is not true that the Constitution does not give us a way out. The Constitution, Betty, if there is not an express provision that answers to a particular problem, then the default position has always been you take what is called a harmonious and purposive reading of the Constitution all the way from the preamble of the Constitution to Article 4, it says Kenya is a sovereign republic, to Article 38, the rights of the political rights, Article 136, 138, 140, all these articles read together, including Article 165, sub-Article 3, which gives the High Court to interpret what the Constitution means in each and every situation. If you take a harmonious and purposive approach, then I see an approach where the court may say, no law is rigid. And certainly, the Constitution is not a rigid document. The Constitution is a growing document able to adapt to situations and scenarios as may. So the fact that the Constitution says that an election must be conducted in 60 days, that is just our guiding light. If there are intervening circumstances, Betty, that makes it no longer tenable to hold elections in that day, then the court, in terms of the hierarchical order, the judiciary, because we live in a constitutional democracy, the judiciary, in terms of interpretation of the law, it is required to interpret the Constitution with finality, and its interpretation is binding. So we can't question the bindingness. Does the Constitution give us opportunities for innovation? The answer is yes. If you look at, for instance, by way of example, the Constitution says in Article 146, in terms of the vacancy in the office of the President, that if the President is not there, for instance, the Deputy President takes over. If both the Deputy President, and the Deputy are not able to, for one reason or another, to continue, the Speaker takes over for a limited period of 60 days for which an election is to be held. There could be circumstances, even under that provision, where the Speaker is unable to take over or election may not be conducted within those 60 days. It is up to the court to understand, interpret the political environment, because elections are not done for people's amusement. Election is not a mechanical exercise. The purpose of an election is to ensure that you have a democratic process that is verifiable, that is credible, that is free and fair, that makes us have an opportunity to elect a president at the ballot.
All right.
If circumstances arise that it's no longer possible to have that situation, we can always vacate that date. But the decision to vacate the date cannot be made in political rallies. So NASA cannot tell Kenyans that there's no election. I believe the clamor for no reforms, no election should be interpreted by lawyers and everyone who lives in this country to mean that it's an election boycott. You see, an election boycott does not mean that there's no election.
There's no election.
It means election is proceeding, but a certain constituency does not believe that the outcome of that election will be free and fair. The only question that I would like to underscore, which I think has been neglected in all this debate, if you contradistinguish, if you compare and contrast pre-2010 disposition and post-2010 realities, there's a stark difference. The important point is this. Before 2010, the justification for boycotting election was always founded in the fact that you couldn't even go to court because the judiciary was considered as a mere extension of the executive and they operated the whims of the executive or the presidency. In post-2010 jurisprudence, and what you have seen from the Supreme Court, the judiciary is one that is impervious to executive manipulation. We have a judiciary that cannot be manipulated by the presidency or the executive. That means there is an opportunity for you as the political opposition, if you believe the process has been manipulated in favor of someone, to document it, present it back to court. Maraga said, let justice be done even if the heavens may fall. That they are ready, insofar as the law is not complied with, to nullify an election. So I think that should also have mitigated on the desire to boycott election. So I understand it as a political action, but election boycott is not equal to no election. So I think it's very important that we clarify those points.
All right. Mamboleo, he says that the constitution is not rigid, and we actually have quite a number of cases, actually 12 to be exact, with regard to this repeat poll. What is your take on that?
I agree with him that the constitution might not be extremely rigid, but not in an unlimited manner. You not just walk to the Supreme Court today and present just any petition and get away with it with an extension of time. You are going to have to show them that there is extremely good reason why they should extend that time. For instance, where a section of this country always shoots itself in the foot is this idea of placing one foot in the grave and then another one on a banana peel. It will never happen. You always need to, there's a sort of consistency that you require. Interpret the Constitution consistently, okay? So you go to the Supreme Court, and the Supreme Court renders a decision, which, by the way, has serious and far-reaching effects on the democracy of this country. For the first time on the African continent, the Supreme Court of the Republic of Kenya has nullified a presidential election. This is the fourth time this is happening across the world. This is a monumental decision, all right? And if there is any section of this country that should be extremely happy with the judicial system, then it is that section which went to court to actually ask for the nullification of the presidential election. What does that mean? That this same court, since it is still available, can always relook at any presidential election and ask itself the question, has this presidential election met the conditions set out in the Constitution? And if the answer is no, then the answer will be that go back and do it until you do it properly. Now, this is what is important. The Constitution as framed cannot anticipate every eventuality ad infinitum. They cannot say, for instance, to give his example, that if the speaker, for instance, is unavailable to take up the position of president of this country, then who next? Until infinity. At some point, the framers of the Constitution have to stop guessing and work within the framework that they have given. For instance, under this Constitution, we have been told under Article 140 that you can go for a presidential election, a repeat presidential election within Article 140, but thereafter, the Constitution no longer tells us what should be done if, for instance, we do not conduct the election within 60 days. This is extremely important for our viewers. Number one, that, you see, let's not even get to a question where we are asking whether we want to go for an extension of time to begin with. I think, in my view, the important question that we should frame for this country is this: is the IEBC, which is vested with the mandate of conducting elections, capable, technically speaking, of conducting the election? And I'm sorry to say, the chairman of the IEBC is a lawyer of many years standing. And I think he's not framing the correct question for his mandate. The correct question for him should never be, is this country in the correct political framework to conduct an election. Because the security or not, that should not be his problem. He should tell the political players, as a senior citizen of this country and a person who conducts election, he should tell government, hey, we are in the process of conducting a highly contested election. Can you provide us with sufficient security to make sure that our officials, together with Kenyan voters, are going to carry out the exercise in order and in a peaceful manner? And at the same time, he's supposed to lay down some rules, do's and don'ts for the political players as the referee, so that anyone who is caught infringing or violating any of those rules then should be brought to book. However, the question whether there is the correct political environment or not to conduct an election should not be an IEBC question. The IEBC should be able to come out and say, hey, we have a problem in Kisumu because there are people rioting there, or there are people who are trying to stop us from training our officials. Can the security agencies take necessary action? Then he leaves the political question to the political players. And we are telling this to the government of the Republic of Kenya, that you have a responsibility to protect every Kenyan, including those who will vote and those who will not vote during the election. And at the same time, we're also telling NASA supporters, or NASA in general, that, hey, you have a right to picket, to demonstrate, or to do whichever you please in relation to this election, but you have absolutely no right to stop this election from happening. So don't do anything which is against the law as you quest to achieve the satisfaction of your right to picket or to demonstrate.
All right. Gentlemen, I want us to now go into the nitty-gritties, and I'll start with this particular ruling that we're waiting for. With regard to David Kosing, he's trying to compel Raila Odinga to actually be on the ballot, and that is going to be decided this morning. Is there a point to compel somebody to run in the election?
Without prejudice to the judgment, I think that petition is dead on arrival. I mean, it's just laughable. You can't go to court to compel a candidate to participate. What you do, you go to court to interpret the consequences, both intended and unintended consequences of that withdrawal, and the court will apply its mind to that issue. You can't, it's not open to you, Betty, to decide how I want to exercise my rights. The only opportunity for you to intervene in the exercise of my rights, if the manner in which I want to exercise my rights, then in that way affects your rights in a significant manner. So I think David's application or petition at the High Court may suffer fatal dismissal at the High Court. If the High Court were to allow, I would be pleasantly surprised and read the judgment with learning, because that would be a new learning for sure. Because what is obvious to us is this: if Raila has withdrawn from this election, Justice Mativo already said in a Kuru judgment that election, in his understanding, is open to all the 8 candidates. So the withdrawal of Raila is inconsequential unless David is litigating a political question. Remember, the question of organizing the politics of a country cannot be litigated, cannot be legislated. Just like to say, in terms of electoral democracy, elections are at the center of democracy. And IBC is at the epicenter of Kenya's electoral democracy. And I want, if you may allow, Betty, to just take you back for half a minute on what Mamboleo was saying, which I disagree slightly. It is not up to, it's open to IBC to assess the environment that is operating its mandate. And if it believes that the environment is not conducive for a return of a free, fair, credible election, it is open to it. Under Article 165, Sub-Article 3, under Article 163, Sub-Article 6, it is open to IBC to seek a judicial, what is called an advisory opinion from the Supreme Court. And the Supreme Court can give it guidance. Let's not limit IBC's opportunity to innovate within its challenges. But at least we have been able to settle one fact. The election is going on as a matter of legality until vacated by a court of law. That is also open for any party to seek advice on postponement of the election. Until such advice is sought and given, we are proceeding with this election as on schedule. But let us not devalue or diminish or decampaign IBC's own idea or maybe interest in terms of making sure that they do a comprehensive assessment of the environment in which they work. What they are not allowed to do is to make decisions arbitrarily because they don't have that kind of discretion. If they believe the environment is not right, it's also open to them to go to court. But insofar as the question you asked, I would be pleasantly surprised to read with learning any innovation the judge will make, because Raila is withdrawing, that is his right to withdraw, and no judge can reinstate him unless the judge wants to embarrass the court.
All right. So